Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo, where we discuss all things estate planning and elder law. And well, hey, anything else we want to talk about. And on today's podcast, we are going to be following up on our celebrity planning successes and fails. So we're going to finalize and work through the rest of the celebrities that I wanted to talk about and what lessons we've learned from them. So that's today's podcast. Now, just as a reminder, please do not take the information that you hear from this show or any other show for that matter to constitute legal advice. If you are looking for legal advice in a certain specific situation, please contact a lawyer licensed in your state to get legal advice for that specific situation. This show and any other show is for informational, educational, and entertainment purposes only. If you'd like to get legal advice to assist you with your estate plan, please give us a call at Belomo & Associates at 717-845-5390 or check us out on the web at www.belomoassociates.com. We would be honored and humbled to be able to assist you with your estate planning and to help you with your specific fact pattern and situation. Well, on the last podcast, we had a wonderful time, or at least I did, talking about celebrities, right? We talked about Elvis Presley, Lisa Marie Presley, Marlon Brando. Remember Marlon Brando? Jimmy Dean on the cover of a magazine. Dietrich and DeMaggi. Anyway, I digress. My apologies for that. We talked about James Gandolfini. We talked about FloJo, Michael Jackson. We talked about a lot of wonderful celebrities. And I would say not all of them were fails. I think that there were some great lessons that we learned, specifically about some of the advantages of trust planning. But most importantly, if you're going to do it, a trust, you have to make sure that it's funded. You have to make sure that your boxes are put in the wagon or that your assets are put in the trust. I think that was the big lesson. And then a second one that we learned was Elvis had the trust dissolve at 25 for Lisa Marie. And because of that, she squandered and lost a lot of the inheritance. Luckily, she was able to protect and preserve Graceland through a trust for her 3 daughters, but that could have gone horribly wrong. And I think we learned there not to be dissolving trusts too early. It's better to have things protected. Not that we have to protect people from themselves, but let's protect assets for our loved ones. So we'll continue on in our celebrity podcast journey. The next celebrity I want to talk about is Whitney Houston, right? A singer. I think a lot of us know who Whitney Houston is. And the lesson here was not updating her will, right? So she did have a will when she drowned in February of 2012, but it was extremely outdated. It was drafted 1 month before 93, the birth of her only child, Bobby Christine Brown. Whitney's Houston's worth was about $20 million at death. The daughter, Bobby, inherited 10% of the estate, which means she got about $2 million at age 21 and the rest later. Now, 21. What do we think? Is a 21-year-old ready to handle $2 million? I don't think so. And I don't even think it's $2 million, right? I mean, in my workshops on a weekly basis, I'll say, is an 18-year-old ready to handle $100,000? Is an 18-year-old ready to handle $200,000, right? It doesn't have to be $2 million. 50 grand, 100 grand, right? The probability is that a 21-year-old is not ready mentally and emotionally to be able to handle it. So in this case, Bobby did get a large lump sum at 21. She died in 2015, about 3 years later, as a result of a drowning and a drug intoxication. Now, I don't know the details. I don't know if it was because she had all that money that she was able to overdose or become, to the situation where it drowned. I'm not saying anything about that. I am just simply saying that giving that kind of wealth to anyone at age 21 is not a good idea. And again, it didn't have to be that much, right? I still think 100 grand, 50 grand, 20 grand. Why are we giving money outright to somebody at age 18, 21? And I think the reason that you find those ages to become very prevalent is because A person is deemed to be an adult at age 18, which means at 18, if you beneficiary designate assets to a beneficiary, that's when they get the lump sum. And then some fancy lawyers will do, I'm going to transfer it into a uniform transfers to minor's account. That's great. Better than them getting it at 18, but now they're getting it at 21. Again, is a 21-year-old ready to be able to handle that type of wealth? No, I don't believe so. I think that when you're at that age, whether you go right into the workforce at 18, whether you go off to college, you're still trying to figure things out. You're still in relationships that may or may not work out. You're still trying to find yourself. I think giving outright money at 21 is a horrible idea. And in this case, I believe it ultimately was somewhat a factor in the future. So I really think that getting the assets protected is the lesson. And I think that the follow-up lesson is that 21 is way too young to get a large amount of money. One of the things that we have seen over the years is an old tax thing that a lot of people would do is a third at 20, a third at 25, a third at 30, or a third at 25, a third at 30, a third at 35, whatever. That isn't necessarily the best idea, right? Because when you give somebody an outright distribution of a third, for example, at 25, anyone can take it. If there's long-term care situation, if there's an addiction, if there's a divorce, if there's outside factors. So we don't generally give outright, distributions, a third, a third, a third. We say, at what age do you want your child to be in full control of their money? So if your age was 35, go with 35, but don't give an outright third at 20, 25, 30, or 25, 30, 35. Simply say, at 35, they're in full control. Prior to that, the money will be given to them through the trustee, the sole and absolute discretion of the trustee. That allows us not to be giving an outright distribution of a third, a third, a third, and then take the chance at losing it. From the little bit that I can tell from this case and the research that I did, is that there were assets that were protected later, right? She got a percentage at 21 and then got more later, but the percentage that she got was enough to ultimately lead her to making decisions, getting access to things that she may not have otherwise had, and ultimately passing with a drowning a few years later, which is horrific. So our next celebrity we're going to talk about is Robert Kardashian. Now, a lot of us know who the Kardashians are because of the Kardashians, right? But the older generations, right? I vividly remember watching the OJ trial when I was growing up. And I remember watching it and looking at Robert Kardashian as an attorney for OJ. So that's how I remember it. I think mostly the people now will remember through the Kardashians, the daughters, Kim, Khloe, and Kourtney, and then there's a son, Rob. So anyway, the lesson here is the issue of a holographic will. And I'll explain kind of how all this ties together. Yes, Robert Kardashian was an attorney, very famous, very well known, had the 4 children and a wife, Ellen Pearson. They got married 6 months before he passed away. Robert was an attorney in the OJ trial. Now, this diary or this holographic will, the children are adamant that it was fake. And they wanted handwriting experts. They wanted it to be analyzed. There was a major dispute among them. The will that Robert had said all intangible property and tangible property would be distributed to the trust for his children's benefit. The will provided his wife Ellen would be given the Indian Wells property and its furnishings. So furnishings, right? You got a little bit of contradiction here. You got all intangible and tangible going to the children in a trust, and then the Indian Wells property and its furnishings going to the wife. Now, the diary gets found. It's handwritten. The kids say it was fake. The kids say it was forged. The kids say it's not real. Was that part of the furnishings? Was it part of the property, tangible and intangible? Ultimately, I think that the lesson here is, again, pay attention to details. Words matter, right? So we want to make sure that we are very clear on what we want people to get, who we want to get it. Ultimately, I think that turned into a pretty ugly situation. Most of the wealth was certainly taken care of in the trusts for the girls. And as we've seen from the reality shows, and they were able to use the money to do that and to leverage that, certainly the children are taken care of. And it's my understanding that the Indian Wells property is what he wanted his wife to get, which she did. So I think all in all, that situation turned out pretty well. But I think that the details, I think that the attention to details, words matter, being specific. Again, that goes back to defining words in documents, which is why we have a whole section in our documents that define words. I understand that a large will, in terms of numbers of pages, can be intimidating, or a large trust can be intimidating. But the reason that there's a lot of pages is because of the details, because of the specifics. Words do matter. And I think that was the lesson that I learned from the Kardashian case. And that little play on the words, right? Was the diary, was the written instructions, was that part of intangible property? Was that part of furnishings of the house? Generally, not. Furnishings are usually the stuff in the house, but regardless, let's be very specific, and let's also be detailed in our estate planning. So that was the lesson from the Robert Kardashian. Heath Ledger, an Australian actor, very fond of Heath Ledger. I think probably most well known for Joker in The Dark Knight. I think that was one that I believe, if I'm not wrong, he passed away during the filming of that show, but very, very good. I believe he won a posthumous Emmy for that, or some big award after he passed. Definitely probably one of his most well-known works. I think another one was Brokeback Mountain, and there was a few others in there that were really, really good. Heath Ledger. Now, he did die in 2008. The lesson from the Heath Ledger case is it was an outdated will. So Heath Ledger had a will, and he left half of his estate to his parents and the other half to his sisters. Now, he did have a girlfriend, Michelle Williams, and they had a daughter, Matilda, 3 years earlier in 2005. And then he never updated his will. All right. Now, we did mention this with another celebrity on the last podcast about afterborn children. And the lesson of that was, let's not count on statutes. Let's not count on luck. Let's not count on, let's make sure that we put a provision in for afterborn children. Now, here's the example, right? So in this case, it didn't work out like in that case. And in that case, there was a New York statute that said afterborn children are provided. But because of, in this case, he didn't have any other children, he never provided for children. And so therefore, it went to his parents and to his sisters. They gifted the money to the daughter. All right. So it worked out, right? We got lucky. And as I always say, luck is not a plan. We don't want to count on luck, right? What if the parents and any of the sisters were already in a divorce, already in a nursing home, already in a car accident, had already had something bad happen, or already had creditors who they owed? They would not have been allowed to gift the money to his daughter. It's the same as when I say not to put your kids' names on your houses, not to put your kids' names on accounts and those types of things. It's this right here. We don't want to count on luck and someone being able to transfer it. This is why we don't want to rely on other siblings to provide for a special needs child, right? Put it into a special needs trust. Don't count on one child to be able to distribute it, to be able to give it. Yes, maybe they will do the right thing. But what if a bad thing happens to a good person and they can't? You don't want to rely on someone transferring something when they may not be able to. This is a case that's the prime example. The parents and the child were able to, but we don't want to count on luck, right? One of the other stories I always give is intestate succession, and how a family friend of mine, they husband and wife, Husband passes away, doesn't have a will. The wife and the 3 sons come into my office. They believe everything is going to transfer to the wife, but the truth is the wife got the first 30,000 and split the remainder with the children. The children did transfer the money to the mom. We got lucky. Same thing. We don't want to count on luck, because if any of them had a situation, we wouldn't be able to do it. So be detailed. Put it in writing. Put it in effect. Make sure you get it protected. And that's the example here. Heath Ledger's daughter did end up with the money, but we got lucky. We don't want to rely on government rules. We don't want to rely on things not changing. So that's the Heath Ledger lesson, which I think is a very, very good lesson for a lot of us to remember, that we need to be detailed. We need to make sure that we update as life changes. You should be contacting your attorney every 1 to 3 years. You should be checking in. You should be getting updates. You should be getting those power of attorneys updated. If you haven't talked to your estate planning attorney in a couple years, it's time. Reevaluate your life. Look at your situation. Get those documents updated. Make sure that they work when you need them to work. Prince. Prince is another real big, well-known, yes, $200 million estate. So we're not talking about the wealth as far as relation, but he died without an estate plan, right? He had no will or trust, and he had $200 million. I believe Prince passed from an opioid overdose at age 57. There were no children, no obvious heirs. 45 people claimed to be an heir. Siblings, half-siblings, nieces. I believe there were even supposed children who were trying to prove that they were children of Prince. The ending is irrelevant to me, right? It's the lesson that we're learning. We know that in 2018, $6 million had already been spent on legal fees. And take it down into its simplest form when dealing with individuals, everyday individuals like us that don't have $200 million, right? Even if we have a very small estate, if you spend $5,000 in legal fees, $20,000 in legal fees, $50,000 in legal fees, the percentage is still similar, possibly, or even worse than spending $6 million on a $200 million estate. So have something in place. Don't count on the government. Don't count on people not fighting. Define words in the document, right? This goes back to the definition section of our estate plans, where we are defining the words that are most commonly litigated. People don't fight over what mom wanted. They fight over what mom intended, or what I know mom meant. But if the documents are very clear, child means natural born or adopted. And if I don't provide for a stepchild, specifically saying that I'm providing for the stepchild has no standing. If that's not in there, stuff like this can happen, where a stepchild can bring a suit and parade in teachers and coaches and talk about how mom said she loved him. Yeah, mom loved him, no doubt. But mom didn't intend to provide for him because he was not a natural born or adopted child, and she did not specifically provide for it. But we need to put that definition in the document of child, natural born or adopted. Words matter. Details matter. And that's the lesson that we learned from the Prince situation, is that estate ended up, they ended up spending $6 million on litigation because there wasn't anything in place. Don't count on the government. Don't count on, the right people coming forward, because I promise you, the wrong people are going to come forward as well. The next celebrity plan, and actually this is probably going to fall under one of the ones that I think probably worked out, I think, in the end. Brittany Murphy. I think she was an incredible actress. She passed at the age of 32, which is really horrific. I think she was going to be one of the best. She was married for 2.5 years. He was her agent, business manager, and makeup artist, which cool that he could do all those things, but incredible. There was a handwritten will originally, which is a holographic will. And yes, Pennsylvania does allow for holographic wills, naming the mother as the beneficiary. She then subsequently met with an attorney, updated her estate plan, and did a will and trust, and still provided for the mother. And in the document specifically said, I am married. My husband is, right, Simon, who I have intentionally left out of this will. So she did it the right way. She didn't rely on that holographic will. She didn't rely on the old document that she had from years ago. When she got married, she redid her estate plan. She did a new will. She did a trust. And she said, I'm married. And I'm intentionally omitting him. She did the right thing. And it did go to the mom. And everything worked out. As I said, she died at the age of 32, which is horrific. Way too young of an age. A brilliant actress. But the key here is that she did the right thing. She got it redone. Now, I do want to remind people, in the state of Pennsylvania, spouses have the right to an elective share, which is a third. So if I'm married, even if you specifically disinherit me, I can file against the will, against the estate, and get an elective share right of a third. Now, there's other podcasts and shows on what is the elective share right and what does it include and what doesn't it include. Not important for today. Today, I think the lesson is, yes, she did it the right way, but I also want you to understand that without a prenuptial agreement, and maybe they had one, I have no idea, but in a prenup, you could specifically say, and I am waiving any elective share rights that I may have. But I do want to say this and remind you, as we age and as we get older, second, third marriages later in life, people will do prenups, thinking that therefore what's mine is mine, what's his is his, hers is hers. But the state of Pennsylvania is not a party to that prenuptial agreement. So if one of the parties has a lot of money and the other one doesn't, and the one not with a lot of money ends up in a long-term care situation, the assets of the other one are potentially at risk. So I just want to remind us of that. There are implications, elective share rights. The state of Pennsylvania may force the spouse who is receiving Medicaid medical assistance to file an elective share right to receive a third, but that's not the point. The point is she did the right thing. She updated it. She specifically provided for him and ultimately wrote him out, and the money did go to the mother. So I would say that's an estate plan success. So good job, Brittany. Aretha Franklin. This is one of my favorites. I think I've actually talked about this somewhere else on another show, but as I was doing these, I couldn't leave her out. She's one of my favorites. And just as an ode to her, R-E-S-P-E-C-T. Yep, I love that song. One of the greatest, definitely, of all time. No will or no trust upon her death. All right, for somebody that well known, craziness. She became incapacitated. She couldn't actually do one. She had 4 children, 4 sons, I believe. One of them who had special needs, worth about $80 million. She did pass from pancreatic cancer at the age of 76. Now, here's where things get interesting. There were 2 handwritten wills found in the house. One in the seat cushions of her couch, and I believe one in a cabinet somewhere, if I'm not wrong. In Michigan, there was a 2-day probate trial. Probate is what we go through if there is no will or if there is a will. That's the court proceeding. It's a public process versus if it was a trust, it would not be. 2-day trial, and the court did rule that the 4-page document that was written by Aretha Franklin found in the couch cushions will serve as the will. The jury had decided between the 2 written documents as to which one would be the will that they would probate, and they did make that determination. And of course it did matter because the 2 documents were contradictory in terms of who would get what. I believe one of them actually, if I'm not wrong, wasn't notarized, and I believe one of them wasn't even witnessed. But ultimately, the jury heard the case and decided on which one to go with. Again, all kinds of lessons here, right? We want to get something formally done. We want to get it done the right way. We want to get it, it in writing, dot our I's, cross our T's. But the other lesson I think we learn here is that if you do have writings in your house, don't have more than one and make sure they're not contradictory. Like, I think that might even be the bigger lesson here is they were trying to figure out what her intent was. Well, when you have two writings that contradict each other, it is hard to determine intent. And I don't know the specifics as to whether there were dates on them, whether there wasn't dates, whether it was just as simple as the fact that one was notarized and one wasn't. Again, I'm not trying to get into the legal aspects of it. This is what lessons did we learn. The lesson here is get an estate plan done properly with a professional. But if you're not going to do that, at least make sure that the writing in the house, it's only one and it's not contradictory with something else. And why leave it in the couch cushions? Like, that is crazy. What if they never found that? What if they didn't find it till later after someone bought the house and they found the couch at an auction, right? So that is definitely, especially for somebody of that kind of wealth, but not even, just any one of us, make sure that we have it in writing and that it's in a place where people know. That was another one of the lessons that we learned, was have the will in a location where people know where it is, and definitely don't have contradictory. I'm going to end my last celebrity. This has been so much fun for me, but I'm going to end with Casey Kasem. I grew up listening to Casey Kasem, American Top 40. For those of you who know who I'm talking about, you know the voice. You can still hear him. You can still hear Casey Kasem, American Top 40. Like, I have that voice ingrained in my head. One of the most amazing voices, I believe, of all time. He did end up suffering from Lewy body dementia, Parkinson-like symptoms, and really struggled towards the end there. 2007 and 2011, he had created conflicting documents. Who was in control? The daughter or the wife? There was a vicious family fight between the wife and the 3 children from the previous marriage. There were wrongful death lawsuits filed by the children, filed by the wife. Estate was estimated between $80 and $100 million. One of the other things that I don't know if many of us realize, and I figured this out one day, Casey Kasem was the voice of Scooby-Doo. Again, I just think the guy has one of the best voices. Earl Jones, I think, is probably another one, right? The gentleman from Field of Dreams. But definitely Casey Kasem. I watched a little documentary on Casey Kasem. It was like a 40-minute documentary online. And it was fascinating to listen to his wife and his children talk about it and talk about how, she killed my husband, she killed my father. It was brutally horrific as far as how that ended. And the lesson is that there was conflicting documents as to who was in charge. And because it wasn't clear who was in charge, we're relying on the government. And a lot of government statutes, when there's a wife and there's children from another relationship, say that essentially they're all involved. They're all responsible. Well, we know what happens when that happens, right? Fights ensue. And we're talking wrongful death lawsuits. We're talking not only are they fighting over what's going to happen, they're saying that this lady killed my father. His kids killed my husband. Like, craziness. But if you really bring it back to the root, it's that it wasn't clear. Who was in control was not clear. Please don't rely on the government to make those decisions for you. Or again, back to that lesson from the last celebrity. If you're going to pick it and you're going to put it in writing, then get rid of the old documents that have conflicting terms. Definitely. Make sure that it's very clear what your intent was at the time that you did it. I think that was another big lesson. I have truly enjoyed talking about celebrities. This was like a trip down memory lane for me. A lot of these celebrities were people I grew up admiring, respecting, listening to, watching on the screen, just really, really fun for me. And not all bad, right? We had some good lessons, some bad lessons. But overall, I think the lesson is to get your document in place, to get your estate plan in place, regardless of the amount of money that you have. Get those powers of attorney in place. Get it done properly. Get it done by a professional. And keep it updated. Make sure that it works today and tomorrow. Well, thank you for joining me on this episode of the Red Wagon Estate Planning and Elder Law Show. I'm Jeff Palomo. I hope you enjoyed this podcast, and until next time, we'll see you real soon.